confirm my appearance on behalf of the fourth applicant, accused number 1, 3, and 8. Please go to the machine. We are ready to proceed.
I please show Your Worship, I confirm appearance for accused 5, 6, 7, and 10. We are ready to proceed.
Please, the court, Your Worship, I confirm appearance on behalf of accused number 4. Standing in for Mr. Eno on behalf of accused number 2. We are ready to proceed.
May it please the court, Your Worship, I appear for accused 9 in this bail proceedings. We are also ready to proceed.
We can proceed. So you are still under cross-examination.
Okay, Worship.
As it pleases the court. Mr. Mulunga, you are aware that I'm acting for accused person number 9, Mr. Nandawe, in these proceedings as it pertains to bail.
Yes, I'm aware, Your Worship.
So I have a few questions to you that we just need to get through. Not a lot of contentious issues, just a few things that we need to sort out.
Okay, Your Worship.
Okay. The National Petroleum Corporation Pty Limited and Namcor Trading and Distribution Pty Limited. Those are two separate companies, is that correct?
That's correct, Your Worship.
How are the two companies related to each other, sir?
Namcor Trading and Distribution, Pty Limited, is a subsidiary of the National Petroleum Corporation of Namibia, Namcor.
Okay. During your tenure, what position did you occupy in relation to Namcor Petroleum Corporation? I mean National Petroleum Corporation, sorry.
Yeah, I was the managing director of that entity.
Okay. What was the position that you occupied in relation to Namcor Trading and Distribution Pty Limited?
I was a director, the managing director of that company.
Okay. So let's just get that clear. In respect of the National Petroleum Corporation, you were the managing director and then an ex-officio member of the board of directors.
That's correct, Your Worship.
And then in respect of Namcor Trading and Distribution?
Yeah, I was also a director, basically the managing director of that company, also the ex-official
Okay.
member of that board, Namcor Trading and Distribution.
All right. So there's reference being made in these proceedings to petroleum products. If you were to explain that to my 13-year-old son, how would you explain petroleum products in this context?
Petroleum products are basically products that are refined from crude oil, that are refined to be used as end products in vehicles and farming equipment and so on, and aeroplanes and mines and things like that.
Okay, so would that include fuel?
That's correct. It includes fuel.
That would include then petrol and diesel?
That's correct, Your Worship.
Would that include oil?
Yes, it does include oil.
Okay. So if I say to you that Namcor Trading and Distribution, as part of its daily business, would also supply petroleum products to resellers of such petroleum products, would I be correct?
You would be correct, Your Worship.
Would I also be correct if I apply that statement in respect of the National Petroleum Corporation?
No, you wouldn't be correct if you apply it to that entity.
All right. Is that because that Namcor Trading and Distribution was then created for that specific purpose?
That's correct, Your Worship.
Okay. During the period 1 December 2022 until 31 May 2023, you have that period?
Yes.
Can you just repeat the period?
As it pleases you, Your Worship. during the period from 1 December 2022 until 31 May 2023, what position, if any, did you occupy?
Yeah, I was still the managing director of the National Petroleum Corporation of Namibia Pty Limited, and I was director and managing director of Namcor Trading and Distribution. However, I was suspended on the 4th of April 2023.
Okay.
So I was no longer in Namcor, and I had no authority to make decisions after the 4th of April 2023.
Okay, just repeat for me the date of suspension again.
The 4th of April 2023.
Okay. And during the same period, being 1 December 2022 until 31 May 2023, what position, if any, did Mrs. Jennifer Hamukwaya occupy?
I'm speaking under correction because her contract had expired at some point, so I'm not so. Yeah, I'm not so sure. Cannot remember.
Okay. Furthermore, during the period 1 December 2022 until 31 May 2023, what position did Mr. Cornelius Petrus Willemse occupy, if any?
He also had, I think, left the company at some point, so I cannot remember exactly what the time period is that he was the supply and logistics executive or acting executive.
Mrs. Hamukwaya's position when she was still at the National Petroleum Corporation, was she the executive in charge of finance?
That's
and
correct.
Procurement?
That's correct, Your Worship.
In that position, when she occupied it, was she reporting to you as managing director?
That's correct, Your Worship.
And then Mr. Willemse, when he was still employed at the National Petroleum Corporation, what was his position, if you recall?
Yeah, he was the executive responsible for supply and logistics at Namcor.
Okay. Was he the executive or was he the acting executive? What was his substantive role?
Yeah, I think he was the acting executive, as far as I remember, of Namcor Trading and Distribution.
Okay. And then to whom did he report in that position?
He also reported to the managing director, which is myself.
Okay. So if you have regard to Mr. Willemse and Ms. Hamukwaya, were they on the same level substantively?
Yes, those positions are all executive positions that report to the managing director.
Okay, thank you. So if...
Mrs. Gebhardt, maybe you, before you proceed, for the record, when you are referring to Mr. Willemse and Ms. Hamukwaya, can you refer to them as accused number 2 and accused number 3?
I will do so, Your Worship, as it pleases you. Okay. Thank you. Generally, in that setup of yours, who would be responsible for the final decision to approve a fuel reseller or petroleum products reseller?
I mean, all final approvals and signatures are done by the managing director.
Correct. All right. And then that culminates in the entering of an agreement, isn't it, between Namcor and the resellers?
That's correct, Your Worship.
And those agreements we would call fuel supply agreements, isn't it?
That's correct, Your Worship.
And those fuel supply agreements, the signatory to those agreements in respect of your employer would be yourself.
That's correct.
Maybe while we are there, I have requested a copy of the fuel supply agreement between Namcor and Petroleum Erongo CC. I haven't been finished with that yet because I asked for it just before we started, but I'm just going to deal with the general framework of those agreements with you and just get the picture for the court to understand.
Yeah.
Okay. So we've now established that the signatory on behalf of your employer would be yourself. That's correct?
That's correct.
Okay. So if we, for example, use the bundle that was given to you by your representative, there is one agreement of that nature at paginated page 185 of the bundle of documents. One such agreement you will find at 185. Once you are there, you can just inform me.
I'm there, Your Worship.
Okay. All right, so that is typically the kind of agreement you would enter into with the fuel resellers or petroleum products resellers.
That's correct, Your
Okay.
Worship.
And in terms of those that agreement, there would be, it regulates then that relationship.
That's correct.
Okay. I've also seen, and I want to just ask you to agree with me that most of those agreements, the payment terms for the resellers is 30 days as a standard.
It depends on what was agreed. Sometimes 30 days, sometimes 60 days, sometimes 90 days. Depends.
Okay. So there is something called a credit policy for for your employer, your erstwhile employer. That credit policy, I've seen says it's 30 days. However, in exceptional circumstances, those terms of payments can be extended.
That's correct.
At the sole discretion of Namcor.
That's correct.
So we were now at 185. I want to propose to you that those agreements with the fuel resellers also contain dispute resolution clauses.
That's correct, Your Worship.
Okay, and that you will find, for example, in this one with Enercon, you will find at page 203, clause 17.
Yes, that's correct.
So there is an arbitration clause.
That's correct, Your Worship.
That arbitration clause first says deal with debt collection. Sometimes there's debt collection in terms of the credit policy of Namcor, but where there are disputes other than debt collection,
Yes.
you must take it to arbitration. Am I correct?
You are correct, Your Worship.
Okay. So if I were to invite you to agree with me when I put the following statement to you, what would you say? And that statement is, if you look at the credit policy of Namcor, it excludes the institution of criminal proceedings against debtors of arising from the fuel supply agreement. It's not the policy of Namcor to lay criminal charges when there's payments outstanding.
Yes, I would agree with that statement.
Okay. So Namcor has decided when we deal with our customers, because that would be what those sellers are to Namcor.
Mm-hmm.
When we deal with our customers and they haven't paid, we first do debt collection in terms of our credit policy. Is that correct?
That's correct.
And in the event that debt collection does not yield the results we want, we can also, if there are other disputes, go to arbitration. Is that correct?
That's correct.
Okay. These fuel supply agreements will you be able to tell us if you've signed on behalf of your erstwhile employer 5, 6, 100? What's the range? Because I want us to understand that this is not a unique agreement that was entered to with these entities. Give us a range in your tenure.
I must have signed at least a dozen or dozen and a half of this type of agreements.
All right. Then I want you to please, I don't want us to waste time by going to the agreement. The asset purchase agreement, which is at the center of these charges. Before I get to that, do you know who is the complainant in this matter?
I really don't know who is the complainant,
Yeah.
Your Worship.
Was it put to you who actually went to lay these charges at ACC? Do we know the identity of this complainant?
I do not know the identity, but I can assume who it was. But yeah, I don't know for sure who it was.
Okay, so let's go to the asset purchase agreement. Mr. Mulunga, there's something that I feel, or I'm of the view, on behalf of my client, was left out. The asset purchase agreement, Your Worship, you'll find that at bundle D1, exhibit D1, I believe, that was ended up by Mr. Namanje. It should be page 51.
Can I have one more exhibit?
Your Worship, you can borrow mine if yours is not there.
Exhibits have not been provided.
Okay.
Exhibit
That would be exhibit D1 and page 51 thereof. Are you there, Your Worship?
Yes.
As it pleases you. Mr. Mulunga, I'm not going to do a lot of things here. Just want you to please go to clause number 3.1 of that agreement, because I think that is one aspect that got completely lost in these proceedings. That would be page 55 in the bundle, paginated bundle, and clause 3.1 of that agreement. Mr. Mulunga, is it correct that that agreement at 3.1 states that following the transfer of ownership of the assets from Namcor Trading in that agreement at the same time authorized Enercon to utilize and store their petroleum products that are procured from Namcor in those assets?
That is correct.
So it's a purchase from Enercon, and then at the same time you said once transfer is taken, Enercon now has the right and authority from the new owner, Namcor, to utilize. But you preclude them from storing other products.
Other companies' products.
Other companies' products.
That's correct, Your Worship.
Furthermore, and this point is important because a lot was made about Namcor never took ownership or possession or delivery. May I invite you to go to clause 3.2 of that same agreement? 3.2.
3.2.
Yes.
Okay, Your Worship.
Is it correct that that clause says that Namcor may at any time remove, replace, or modify the assets or any part of those assets at its own discretion?
That's correct, Your Worship.
Mr. Mulunga, Erongo Petroleum CC was also a customer of your erstwhile employer, is that correct?
That is correct, Your Worship.
And if I were to propose to you, and I want your confirmation if it's correct because I don't have the agreement with me, that the fuel supply agreement between your erstwhile employer and Erongo Petroleum CC was signed by yourself on behalf of Namcor?
I cannot confirm that.
Is it possible?
It's possible, yes, but it could also be possible that it was maybe signed before I came to Namcor. But yeah, I cannot confirm that. But if the agreement was entered to during the time that I was there, I would have been the one who would have
To
signed.
sign, correct. And if I were to make the following statement, would I be correct? At all times, the representative of Erongo Petroleum CC, who would be engaging with your erstwhile employer, was a certain Mr. Austin Elindi. Would I be correct?
Yeah, you would be correct.
Okay. And then the next question would be, accused person number 9, my client, Mr. Leo Nandaro. How do you know him?
I do not know him. I met him for the first time here at the court.
Okay. You meet him here for the first time. Are you aware that he is charged with making a misrepresentation to Namcor?
Yes, I am aware of that.
Okay. However, you meet him only here for the first time.
That's correct.
The previous question I asked you around who would typically be representing Erongo Petroleum CC, we agreed would be Mr. Austin Elindi. That is also in line with my client's instructions because that special power of attorney was granted to Mr. Austin Elindi. Do you have any comment to that?
No, I don't have any comment. I'm not privy to that information.
You would also not be privy to who exactly holds any membership interest in petroleum, Erongo Petroleum CC, wouldn't you?
No, I wouldn't be privy to that.
All right. Your Worship, those are my questions to Mr. Mulunga. As it pleases the court.
Advocate Ilunga.
Now, Mr. Mulunga, just to start, Peter Elindi, let me just get the accused 5 and 6, Mr. Peter Elindi, and accused 6.
Can you, for purposes of these proceedings, can you refer to
As the
accused 5 and 6 as the first and second applicant?
Yes, I'll do that. Okay. So the first applicant, Mr. Peter Elindi, and the second applicant, Mr. Malaki Elindi, are they known to you, sir?
Yes, they are known to me.
In fact, we have heard from the evidence of yourself and as well as from them that they are from Omuntele, the same area where you come from in northern Namibia.
Well, yeah, they were born in the same villages.
And your relationship, apart from Namcor having purchased the assets from Enacon, your personal relationship with the first and the second applicant is actually good.
Well, yeah, it's not bad, but I mean, I actually never really had a personal relationship with them until I was introduced to them when they were doing business with Namcor. I knew of them, but yeah, I didn't really know them very well.
All right. Now, you agree that the National Petroleum Corporation, in other words, Namcor, is 100% owned by government.
That is correct.
And it also receives.
Just be slow.
Apologies.
You can proceed.
And it receives funding from government as well, the
That-
National Petroleum Corporation of Namibia.
That's correct.
And the National Petroleum Corporation, or NAMCOR, also has 2 subsidiaries, as you mentioned.
That is correct, Your Worship.
One of them is NAMCOR Trading and Distribution.
That's correct, Your Worship.
And also, with regard to budget, it also receives money or funding from government as a subsidiary of the parent company, NAMCOR or Namibia Petroleum Corporation?
That is not correct, Your Worship.
Okay, so as a subsidiary of the parent company, Namcor, are you saying Namcor Trading and Distribution had a different budget from the one of the parent company?
That's correct.
Say, I put it to you that that proposition you are trying to put to court is absolutely not true. That Namcor Trading and Distribution is a different entity from the parent company, National Petroleum Corporation.
Now, this is a different entity because it has a different name, it has a different board of directors.
Okay, but during your tenure as the managing director of National Petroleum Corporation, you were the managing director of the parent company as well as the subsidiary. They did not have different managing directors, is it correct?
Yes, I was the managing director of both. I mean, in fact, I was the director of both companies, and I was the managing director of both companies.
So how then plausible is your explanation to say you are managing this and the parent company, but yet you are saying it's a different entity altogether from the parent company? Namcor Trading and Distribution, you are saying, yes, well, I was the managing director of the parent company, but...
Objection, Your Worship. I think the question being put to the witness, with due respect, it's a question of law. As we indicated during the opening statement, we have shown that the Namibian or Namcor Trading and Distribution is registered as a private company with a different registration number in the National Petroleum Corporation, a creature of the statute. There are two different entities. You can have two schools being headed by one principal. It doesn't make them one school. I think it's unfair to carry on with this question because this will be apparent during the closing submission. Please go to worship.
Advocate Lungue.
Well, Your Worship, with regard to the objection that is being advanced, we are saying National Petroleum Corporation controls Namibia or Namcor Trading and Distribution. And therefore, they cannot be separate entities because they all receive funding from government. In fact, that is our position from the statutes also. It's a state-owned enterprise which does not have a separate legal entity from the parent company. So what is being said is lies. That is not according to the law or the correct position in the law.
Yes, the issue about the two being separate legal entities was put on record by the applicant himself, that's applicant 4. Therefore, the court will allow the questions. He can comment if you have any comment. The objection is overruled. What is your answer?
What is the question, Your Worship?
Yes, I'm saying these two entities, the Namibia Petroleum Corporation, Namcor, the parent body, and Namcor Trading and Distribution do not have a separate legal identity. They are one and the same.
I disagree with it, Your Worship.
All right. Now, let me ask you this. Namcor Trading and Distribution, does it have its own office separate from the one at Aviation Road?
It's housed at One Aviation Road as well,
In the same building?
the same building.
Okay. Does it have a separate salary role, if I can put it that, separate from the parent company, Namibia National Petroleum Corporation?
That's correct, Your Worship.
And you also agree with me, just to put that aspect to rest, that the National Petroleum Corporation of Namibia was established by Section 8 of the Petroleum Exploration and Production Act 2 of 1991.
That's correct, Your Worship.
And therefore, in the same vein, after it was established, the parent company now, the subsidiaries were then thereafter established. There cannot be an establishment of a parent company without the subsidiaries. Then the parent company first and then the subsidiaries. You agree?
Yeah, the subsidiaries were established later.
Okay. Now, Mr. Mulunga, when we have now heard that you were managing both Namibia, let me refer to them as Namcor Trading and Distribution, and Namcor, the parent company. In other words, you wore the same head actually when you were representing the entities, isn't it?
No,
Okay.
I wasn't. Your Worship.
So the analogy you are trying to put, I'll put it to you, is you trying to put the analogy that, well, the head is not part of the body. Is that what you are saying with regard to the relationship between Namcor Trading and Distribution and Namcor, the parent company?
No, it's not what I'm saying. All I'm saying is that according to the law and according to the registration of the companies, these are two different entities with different registration numbers, with different board of directors. That is what I'm saying, Your Worship.
And I would like to put it to you that both Namcor Trading and Distribution and the National Petroleum Corporation are all 100% owned by government. There is no separation there.
That is not correct, Your Worship. Namcor Trading and Distribution is 100% owned by the National Petroleum Corporation of Namibia, Namcor.
Just slow down.
Making, if I may continue, Your Worship, making Namcor Trading and Distribution private company, not a public company.
I want to take you to the asset purchase agreement, Your Worship. That will be exhibit D1 on page 51. And I will specifically proceed to page 52 of that document. And I'm interested in the part where it says, I think it's the second paragraph where it says, whereas Enacon is the owner of certain bulk storage facilities. Do you see that, sir?
As I said, Your Worship.
Comprising those assets and any and all equipment used by Enacon in conjunction with the operation of said assets set forth in Exhibit B attached here to. Hereinafter referred to as the assets. You get that?
Yes, sir.
Okay. Now, to start with, this document is titled Asset Purchase Agreement. With that, we are in agreement, Mr. Mayor.
Yes, we are in agreement, Your Worship.
Yes. And then, when we go to what I've just read to you, you are saying Enacon is the owner of certain bulk storage facilities. Now, we have had conflicting versions in this court. In fact, yesterday in your evidence in chief, or rather in cross-examination by Mr. Namanje, you say you were buying bulk storage facilities from Enacon. Are we in agreement?
We are in agreement, Your Worship.
Just slow down.
Your Worship,
Yeah.
the proposition being put to the witness must be fair and in context. You would recall, Your Worship, that Mr. Namanje asked this witness specifically to classify what these bulk storage facilities are that is referring to. The confinement To simply stating to this witness bulk storage facility situation is under those circumstances unfair, because it was elaborated what those assets are usually.
He has answered and the objection is overruled. Yes. We can proceed.
Thank you, Your Worship. Now, at the same vein, again, you testified that you were buying title, rights, and interest. Is that correct?
Into those assets. That's correct.
But then the agreement that you entered into, by you, I mean you as the managing director of Namcor, which is the National Petroleum Corporation, the agreement that you entered into with Enacon was for the bulk storage facilities.
I did not enter into an agreement with Enacon as managing director of the National Petroleum Corporation of Namibia. I entered into an agreement with Enacon as the managing director of Namcor Trading and Distribution.
Well, I do not want to belabor that aspect because we have gone past that, but you can answer as you please. We'll leave it for argument.
Your Worship, I don't want the witness to be harassed, Your Worship. I think he needs protection from the court. I think the document speaks for itself. The parties to the agreement as per page 51 are not in its right. So whether my colleague for the state wants from the witness that the contract was between Namcor, National Petroleum Corporation, and Enacon, that definitely is not going to help him, because the documents before court, the parties are very clear, and we cannot do anything about that.
Yes, the question was clear, and the answer was very clear that he did not enter as MD of Namcor, but in his capacity as MD of Namcor Trading.
Please, the court, Your Worship.
Yes. We can proceed.
Your Worship, just before I proceed, I just want to alert the court. It's just unfortunate that I did not bring that judgment with me. It's the case of State versus Conradi, which is a recent judgment of the High Court, in which it was claimed that MTC was not a subsidiary of Namibia Post and Telecommunications Holding. In fact, in that judgment, the court says it is indeed true that MTC is a subsidiary of Telecom, and as such, it receives funding from government, and therefore there cannot be a separate entity. MTC cannot claim that, well, we are not part of this entity. So I just want to bring that to the attention of the court. In fact, when we adjourn, I advance that I just give that case to the court.
Can we leave that for
Yes.
argument?
Yes.
Yes, that can be left for argument.
Yes, it's improper.
Thank you. Now, Mr. Mulunga, I just want to also bring you to the attention on page 53, still of the asset purchase agreement. On top where it says, before the effective date, Enacom shall deliver to Namcor Trading all certificates, ownership documentation, and registration documents, asset maintenance record, asset register as signed by the auditors, warranties, if any, or any other documentation necessary to ensure transfer of ownership of the assets to Namcor Trading. Do you see that?
Yes, I see that.
Now, before Namcor Trading, as you are saying, or as the document says, paid the 53,212,000. Did Namcor Trading first of all have ownership documentation that was provided to it by Enacom?
for Namcor Trading and Distribution, the asset register, as signed by the auditors of Enacon, was enough to prove that the ownership actually does belong to Enacon. That's why the payment was made, Your Worship.
Okay, well, my question was specific. I asked you about the ownership documentation, not about the asset register. So let me put it to you, or let me ask you again. Did Enacon provide to Namcor Trading ownership documentation of the assets, the bulk fuel storage facilities? Did they?
Yes, they did.
Okay. Are you in a position to show us? Because we have not seen that. Where is that?
It's basically the asset register.
Okay. You agree with me that the word ownership documentation is not used in the same way as asset register. They are quite different aspects.
Objection, Your Worship. I think the Council for the State must be careful and not give a selective reading to the clause. And let's look at the clause, what it says, Your Worship. It says, before the effective date, Enacon shall deliver to Namcor Trading all certificates, ownership documentation, registration documents, asset maintenance records, asset register as assigned by the auditors, warranties, if any. Then, my Lord, Your Worship, not and underline the word or, not to end. The parties opted to use the word or any other documentation is necessary to ensure transfer of ownership of the asset to Namcor. Please, the court, Your Worship.
Advocate Lilongwe.
I disagree with that proposition because the word asset register and ownership documents are not the same. So he's misleading the court with that objection. And asset register and ownership document, something that is in your register would not necessarily mean it's yours. So there are two different aspects that I'm trying to put to the witness here.
Your Worship, with brief of court, I must write on that point because it involves my clients. When my clients testified, in particular applicant 1 and 2, the issue of the ownership of those assets listed in the asset register was clarified, and they indicated that it came from the accountants to certify that those assets listed there belong to Enacon. And to add to what Mr. Pangamwapo submitted now in respect of the utilization of the word or in that provision is indicative that not all those documents necessarily need to be submitted, any of those documents listed. So in other words, Your Worship, it's semantics, and at the end of the day, it will go to arguments to see whether the word or indicates whether Namcor Trading or Enacon had the option to submit one of those listed documents, or if the word and is used to say all those listed documents necessarily need to be submitted. But the issue of those assets purchased by Namcor Trading belong to Enacon was clarified when my clients submitted their evidence. So I think my colleague should also have regard to that evidence when posting unfair questions to this witness in the post.
Any response?
Your Worship, it is not for the defense to decide how I put my questions. I think the document speaks for itself. I will not be shoved into a corner to prescribe to me how I ask my questions, because the document is very clear and there is no uncertainty of what the document says. So I'm asking about ownership documentation, not asset register. That's what they want me to ask. I'll not ask what they want me to ask, I'll ask what I want to ask. So I think the objection is meritless, it's baseless as well.
Yes, now the question about ownership, firstly, you put it to him that did Enacon provide ownership? And he confirmed yes. Yes. So he is saying ownership was provided. So that answer has been answered, have been put and answered. Yes, whether it's the asset register or something else. Do you understand? But his position is that it was provided, and according to his evidence, the asset register was the proof of document ownership. That is for the record.
That's the purpose.
Yes.
Now, Mr. Malunga, you would agree with me that the document here says asset register as signed by the auditors. Do you see that?
I see that, Your Worship.
Yes. And then there is a document. Just want to get to that document, Your Worship. Worship, it's a document prepared by Ducatus consultants, which are accountants.
What page?
That would be, if I may assist, page 77 of bundle B1. 77 and 76.
Let's proceed to page 76. You
So are you there?
I'm there, Your Worship.
okay? Now, this document, or the document on page 76, it says Ducatus Financial Consultant CC. You see that?
I see that, Your Worship.
And these are the people that, if we can put it that way, that they are the ones that evaluated the assets of Enacon, and the first people, or the entity that also did the asset register of Enacon. Do you see? In fact, it's on page 77, it states that as that.
I don't agree with your first point, that they are the ones that did the, what did you say?
Let me put it this way, Mr. Munga.
Can you maybe just let him finish? Yes.
Yeah, I agree that they are the ones that wrote this letter to me and actually it gave me the proof that this is the assets that belong to Eneco. That I can confirm. I don't know whether they did any other studies. They wrote this letter.
All right. Ducatus Financial Consultants, what entity are they? What do they do specifically?
No, I don't know. I don't know this company.
All right. If I were to put it to you that these are accountants, would you disagree with me?
I'll object to that. But it appears that questions that would have been best suited for applicant 1 and 2 are now being put to this witness. Applicant 1 and 2 clarified that issue and they said Ducatus Financial Consultants are the internal auditors of Enacon. I don't know why my colleague is putting that question to this witness when he failed to put it to the appropriate persons who would have been in the best position to give that evidence.
Yes. Yes.
Your Worship, if I may, in addition to that, my objection is a simple one. The witness says, I do not know these Ducatus. Then my colleague follows up with the question of putting a statement to the witness that he must either confirm or dispute about something that he does not know. That is unfair.
Any response?
Well, he can answer if he had the question.
I did answer your question.
Yeah, he answered. He said he doesn't know. Yeah.
So, Mr. Malunga, with regard to your proposition of saying you do not know, so you received a document from an entity that you do not know what they do. Is that what you are saying?
No, it's not what I'm saying.
Okay, what are you saying then?
I'm saying that we had agreed in an agreement that the internal auditors of Eneco Namibia were to provide proof of ownership of the facilities, and that is what was done.
Okay, so when you received this document on page 76, you received it under what circumstances? Knowing what did it mean to you? It came from what entity?
Now, from the internal auditors of Enecon.
All right. Now, let's go back to the asset purchase agreement.
Which page is it?
Page 54. Just below business check account, and I'll read it to you. Namcor Trading shall not transfer the purchase price to Enacon's nominated bank account until Enacon provides to Namcor Trading proof of ownership of the assets. Do you see?
Yeah, I can see that. Yes.
What proof of ownership of the assets as required by this agreement was provided to Namcor before they departed with their money, 53,204,000?
Objection, Your Worship. That question was asked many times and answered many times. And the witness referred to the said asset register as provided by the auditors of Enacor. Let's not be repetitive, Your Worship. If he doesn't have a question to ask, he can simply raise his case.
Any response?
Well, it's a different question, Your Worship. So because it says before the payment of the purchase price. That's what the question is premised on. And here it says on page 53, that was at the time the agreement was being entered into. And at 54 it says the payment of the purchase price before the purchase price is transferred to a nominated account of Enacon. Enacon should provide proof of ownership of the assets. So I do not think the questions are the same.
Yes, the question is centered around the same issue, even though just phrased differently. So, but then I will just, do you have any other comment? Because it would appear from the applicant, the first applicant, and as much as you put that question, it appears he will not change.
Yes.
Do you have any other different answer?
I have no different answer to that question, Your Worship.
All right. I'll move to page 63, still of that same bundle, which is an offer to acquire Enacon Namibia petroleum assets. Now, Mr. Mulunga, is it correct that it was you that had approached Enacon to acquire the assets?
Yes, according to, as per the provisions of the fuel supply agreement between Namcor Trading, Distribution, and Enacon Namibia, Pty Limited.
And also, according to that letter dated 8 July 2022, on the bottom there it says, yours faithfully, Emmanuel Mulunga, Managing Director. So it was you that made the offer. You agree?
Yes, I agree.
Okay. And what you offered to acquire were the assets, not the title rights, because the keyword being the assets.
No, I don't see the difference.
What do you mean? I'm saying what you offer to acquire is the assets.
Yes. That's what the title says of the letter.
Okay, in fact, it says this offer is to acquire the Enacon Namibia bulk storage facilities. Do you see that?
Yes, I see that.
And nowhere in that letter, if you can read it, perhaps my reading of the letter, you say I'm construing what is there. You do not talk about title, rights of interest in the document, not at all. I think what is spoken about is the assets. Are we clear?
Yes, yes, we are clear.
Okay. So when did the issue of rights, interest, and title then come in? If what you offered to purchase were the assets?
Your Worship, I have to object. We are really going to go and sit the whole year here. The reason why I'm objecting is the asset purchase agreement, which was entered into by the parties pursuant to that letter, specifically describes what is being bought, what is being sold, what is being bought. You will find that at clause 1.1. Now this witness is being asked again, after it's not in dispute between the parties. This witness is being asked again, where does the right, title, and interest in and to the assets come from? Your Worship, we must not forget that in addition to being officers of the court, there are certain things that govern how we do our work. It's not for this court to go into an agreement that is entered into freely between parties that don't involve any of us and go and decide and impose an interpretation to those terms that are enclosed there and agreed to expressly. So we have to move from that premise and cut this fishing exercise that is now transpiring in this courtroom.
Any response?
No, in addition to that, Your Worship, just to cement what my sister just said, you see, when parties sit down and negotiate and conclude the contract, they make offer and counter offers. And the moment they offer whatever is accepted, we have a complete document, which is called a contract. And once we have a contract, the old stories of negotiation, the offers, they are off the table. The issue now we have is the asset purchase agreement as an embodiment of the both parties' terms and conditions. So this issue of offer, commercial offer, it doesn't help the state case, Your Worship. But we argue to that effect.
Any response?
Your Worship, I move past the asset purchase agreement. I'm talking about the offer to purchase, which was before the asset purchase agreement. So I do not see how that question is then raising objections, because in fact he confirms that he's the one that authored the document. So again, I have to say the objection is meritless, is baseless, because I have moved past the
Yes, the question is very, very specific on the offer itself. Counsel is using the words written on the offer itself. So this question is very specific on that offer document. The objection is overruled.
As it pleases the court.
Sir, what is your answer?
My answer is that an offer is usually made. However, the contents of what will be agreed would be contained in a contract that would be negotiated by both parties. Because when you have something like this, one of the parties obviously have to make an offer. And we are the ones that are soliciting for the business. So we make an offer to purchase so that we can supply fuel to the company. But this is not a contract, this is just a letter. The agreements would be then contained in a contract that would be signed at a later stage. And that is what has happened.
According to this document, and you'd agree with me that this document is the one that brought forth the asset purchase agreement. First the offer, and then the asset purchase agreement. Are we together? Are we in agreement?
No, we are not in agreement. The document that birthed this offer is a fuel supply agreement between Namcor Trading and Distribution and Enecon Namibia Pty Limited.
Well, when you entered into the agreement with asset purchase agreement with Enacon, is it not correct that Enacon was actually already receiving fuel from Namcor?
Not on an exclusive basis. They were buying from other people as well.
Yes, but I'm asking, but was there not already a standing agreement between Namcor and Enacon for the fuel supply agreement?
No, there wasn't a fuel supply agreement between the two companies in the form that it is.
Earlier on, you had said not on an exclusive basis. So you are in agreement that Enacon was already receiving fuel from Namcor.
Yeah, well, Enacon was buying fuel from Namcor and other suppliers as well before that.
Okay, so why then are you saying the document or something that bears the asset purchase agreement is the fuel supply agreement when you were already in agreement to supply fuel to them?
Okay, I'll answer that.
May the witness be allowed to answer and also be taken to that fuel supply agreement so that we have a complete picture in Washington. That is at page 185 of the bundle which we submitted yesterday. Because we can't be asking a question from the end without referring the witness, the document we are talking about. Please, about the motion.
Any response?
Your Worship, I do not think I want to go to the document because he has said they were already supplying fuel to Enacon, but not on an exclusive basis. So him referring me to the document.
Yes, Counsel.
Yes.
These documents are already on record. If you tell me he is not asking on the document before court, I would understand. But you want him to go to that document?
No, to assist the witness, Your Worship. Because the witness referred to that same document.
Yes, but if the witness does not understand, he will say, I don't understand the question. The witness is saying, no. According to him, what bears the asset purchase agreement was the fuel supply agreement. Yes.
Yeah, Your Worship, I would like to go there maybe just to answer the question completely. The preamble of that document on page 186 of the bundle.
At what page?
186 of the bundle that was issued by my legal representative. Whereas the buyer wishes to purchase products exclusively from seller for its customer, the Ministry of Defense and Veterans Affairs, Government of the Republic of Namibia. Because there is a difference, Your Worship, between buying fuel from a supplier on a once-off or once-in-a-while basis and when you exclusively purchase from them, because the volumes that Enacon Namibia was supplying to the Ministry of Defense were large volumes, 700,000 liters per month. So if Namcor supplies that entire volume, it's a much, much different proposition than sort of selling once in a while.
Yes, I'm not sure, Counsel, assist if I'm wrong. I'm not sure because your answer was, why does he say the fuel supply agreement bears the offer, the asset purchase agreement?
Yes, that was my question.
Yes.
And the answer is clause 4.5 of that fuel supply agreement. 4.51.
Yes.
And if I may read,
You can proceed.
yes. That clause says the seller and the buyer, this is now the fuel supply agreement between the two parties. The seller and buyer to enter into negotiations with respect to the purchase of all assets, pumps, canopy and tanks and related equipment belonging to the buyer, herein referred to as the equipment, at a market-related value to be established by the parties' joint technical team. The parties further agree to negotiate within a reasonable time an amount that could be set off against the debt owed by the buyer, if any, at the time of negotiations with regards to the acquisition of the equipment. So it is not the offer letter that I wrote that birthed the asset purchase agreement. It was indeed this agreement, the fuel supply agreement between the two parties, that birthed the entire process of asset acquisition.
We can proceed.
Now, sir, is it correct that while you were the managing director of Namcor, there were internal policies and procedures with regard to acquisition of assets?
Yes,
And one of them was that you needed board approval to purchase assets if they are above 25 million.
yes, for you to actually buy the assets, to incur the finances, yes, there are limitations.
Okay, so in respect of the purchase of the 9 fuel stations, or home-based fuel stations as they were called sometimes,
What the witness made it clear that they did not buy any service station. That was clearly said during the examination with chief and the cross-examination by the colleagues. There was no buying or selling of service station. It was the facilities or bulk storage facilities that they called it. Please, what you worship.
well, it's just a matter of semantics.
Yes, just rephrase and then we'll.
Okay, all right. Okay, so when you bought the bulk fuel storage facilities, let me start it this way. The bulk fuel storage facilities that you bought, we have now established that they are worth 53,212,000,
That's correct.
which is about 25 million. All right. Now, when you entered into an agreement to buy those bulk fuel storage facilities, did you have board approval?
Okay, let me explain.
It's not an objection per se,
Yes.
but you should equally be on the same page. Nowhere did Mandela for the state inform the court that Mr. So-and-so will come and testify that there is a policy and this policy says the threshold is 25 million. But if my colleague is in possession of such a document, which I assume he is, it will only be fair, Your Worship, that it be shared with defense counsels so that we can also prepare in respect of that particular document, Your Worship.
Any response?
I'm in possession of it. In fact, yesterday when I wanted to discuss it with Mr. Bangamaho, he had refused to accept it. And I think
Sorry. Pardon me, worship. I'm supposed to keep quiet.
yes, he refused. He said he can't receive documents here. But I told him there's a document. I think why would I do that? Because there are several documents that we have disclosed to them. I'm an officer of court. Why would I stand here and lie? In fact, that document, I have informed him, can you receive this document? He refused to accept the document. So I can't shove it on him if he doesn't want to receive it.
Now, it's clear there was a connection between my Leonard. I'm not saying it's true.
Yeah.
My Leonard friend and Mr. Bang. But by his own admission, Bishop, he excludes us. So we were not informed. We don't know. And like I said, Yosha, I mean, things don't just fall out of the air to be put to witnesses. There must be a fact-based issue that is put to a witness. So Yosha, really, this court has a constitutional duty in terms of Article 12 to safeguard all accused persons' interest in having a fair trial. It is quite clear, Your Worship, that what is happening here is ambush, and it is not fair. The state must disclose to all of us, Your Worship, not only to a particular person.
Your Worship, I'm compared to this because my name is mentioned that I refuse documents, but I must place it on record that I was never approached by State Council proposing to submit or to discover any document relating to any policy of Namcor. The only document which State Council tried to sneak in, and I refused, it was about particulars of the motor vehicle, which document was also not clear. I must place it on record. This is now becoming like a ping-pong game and child play actually. And I'm not happy with the, well, I don't need to be everyone happy, but this approach must be stopped by the court. Please continue.
Any response?
Well, also, for the sake of other witnesses, does not represent the accused here or the applicant in court. So I do not see the basis on which he's standing to object. His client's name was not mentioned, so I think that should also be very clear. Your Worship, with regard to the documents, in fact, it was 2 documents. I don't know if I can then proceed because he has already said it's about 25 million. Here it is.
Your Worship, insofar as it concerns me, and it's not the first time a learned friend has taken this check. First and foremost, Your Worship, the office of this court, and I will not sit by idly and allow an injustice to be perpetrated against any person for that matter. Let me just make myself very clear on the aspect. Secondly, Your Worship, you will remember that the state was brandishing that these are Namcor employees. Surely, Your Worship, by implication, whatever policy the state relies on is relevant to accused number 4. Because it's the state's assertion that accused number 4 was an employee of Namcor. But lastly, Your Worship, we made an undertaking to you about the decorum of this court. You would recall earlier on, Your Worship, instead of dealing with an objection, my learned friend for the state wants to tell the court he will not be bullied, he will not be made to answer questions in a certain way without dealing with the objection. Your Worship, these things must stop. This court must start taking charge of this procedure.
Yes, before the court deals with that aspect, I am inviting both counsels to address me on the issue of disclosure application, because it appears this is around disclosure. Yes.
Well, Your Worship, it is only a basic tenet of the principles of natural justice. Your Worship, you will no doubt agree with me, there is the principle called odi alteram partem. But that being said, Your Worship, the state should not be allowed to play hide and seek. And they must be forthright with these bail applicants before this court. Your Worship, an order was already made before the commencement of these bail proceedings that the state should provide the bail applicants with disclosure of documents it intends to use in these proceedings. also, Your Worship, it is materially unfair that the state would be allowed to use a document in ambush and deny a bail applicant an opportunity to forthright deal with that document in his or her evidence in chief. So that when the state rises to cross-examine a bail applicant in this proceeding situation, they are not taken by surprise. So, Your Worship, we are well within the shadows of what is referred to in the Constitution, Article 12. That accused persons are to be afforded a fair hearing. And when I say in the shadows, Your Worship, it is because we are in the shadows of darkness where things are being hidden.
Any other?
Your Worship, I would just use my colleague's podium. Your Worship, on the issue of bail process, the court to the judgment of versus the state, open bracket CA 38 of 2013, the High Court Main Division Judgment 202. It was delivered on 18 July 2013, wherein the issue of disclosure during bail proceedings were dealt with, and the High Court clearly stated that the accused persons must be informed fully of the charges preferred against them, and they must be provided with any and all documentation that will be used, at least as far as bail proceedings are concerned, in opposition of them being granted or being released on bail by the state. So on those bases, Your Worship, if my colleague accepts and respects authorities of superior courts, the defense would be entitled to any and all documents that the state wants to rely on in opposition of bail to any and all accused persons, including my client, albeit our case has been closed to the court business.
Your Worship, I will not be long because I think we have wasted enough time on this petty issue. Because when you look at the Article 12, Your Worship, it talks about an accused person to be given an opportunity to prepare their defense before they can approach the court. This is a bail application. The state is objecting to bail. They have set out the grounds for objection. And in support of those objections, they must put forward evidence, including documentary evidence. If applicants, as of right, are entitled to receive those documents before moving the application. That is the essence of discovery in the civil matters or disclosure in the criminal proceedings. Otherwise, we wouldn't have any rule relating to discovery or disclosure. You cannot disclose or discover during the proceedings, Your Worship. It's unheard of. I never seen this. These things, a decision must be made. Please, Your Worship.
Your Worship, if I may, I know that the court invited us to make submissions in respect of the issue of disclosure, but I submit with respect, Your Worship, that the issue comes down to just one distinction, the distinction between disclosure of the police docket, which is a separate issue and governed by different principles in our law, and the second one is disclosure for purposes of bail proceedings. So, Your Worship, when you evaluate our submissions, that is the prism through which you must look at these submissions that are being made by all counsel. In addition to that, and that is actually more important. This issue was already overtaken by events. Where we are now is a document was given to one council. So there's no debate about whether they should discover or not. And that is what I understood from my colleague, that he understands the principle pertaining to disclosure in bail proceedings. That is why on the first day he requested time to make copies, because those are the documents the state will rely on to oppose our clients' applications for bail. So that issue is settled. What we are dealing with now is a document that was presented to one council for whichever reasons, and I'm not attributing any malice to my colleague. Sometimes you forget it's a long matter, there are a lot of documents. I'm not saying also that is what happened. Where we are now is that a document was presented allegedly to Mr. Babangwabo. He refused that document, and for some reason that refusal is imputed to all of us. And when it is being raised by Mr. Casper, he is effectively being told to keep quiet because it's not his client. While we know very well that these charges are framed and are related to, the way they framed them is to say people were acting in concert, if I must put it simply. So it might appear to my colleague that it does not affect all our clients in his view, but we are entitled to have regard to those. And Mr. Mbabagwambo's refusal, whether it's true or not, should not be imputed to the rest of us.
Yes.
Your Worship, firstly, I think my colleagues are well aware that this is a bail application. It's not a trial. In fact, I would like to also remind the court, or just inform the court, that during the case for applicant 1 and 2, there were documents that relate to title deeds or documentation with regard to the car. Those documents, in fact, were not submitted when the client was testifying. We were informed that those documents would be available to us at a later stage. So I'm trying to put this in context that in a bail application, it's unlike a trial where we should disclose everything before the commencement of the trial. So in a bail application, we disclose documents as then and at that moment when we have those documents. My colleague should also take into account that at this moment we have to go through a lot of documents, and that's why we disclose them in the manner that we do. And if documents are available to them and they refuse to accept the documents, I must admit that yes, it was to Mr. Bangamabo, but that attitude has also been displayed to counsel, although that is not before court. But what I'm saying is that when documents are disclosed to us by counsel at a later stage, we do not take issue with that, and those documents are submitted to court. But when we want to disclose to them, they refuse the document and say, I'm not going to receive that document. That leaves us in a predicament, Your Worship.
Yes.
That will be all. I leave it in the hands of the court.
Your Worship, I think it's quite important that the record be set straight, and context is everything. Insofar as the make the discovery, my learned friend is now complaining about it came from the end of the accused or the bail application. You will recall, Your Worship, that there was an engagement between Mr. Namangi and the learned friends for the state, where Mr. Namangi informed that the personal particulars of one of the bail applicants were ended up by agreement. And the expectation was that there is no, or at least the understanding was that there was no objection from the state insofar as the contents of those personal circumstances were concerned. Belatedly, the state raised the issue concerning ownership, about title deeds, and so on and so forth. You will recall, Your Worship, that the next day Mr. Namangi came here with a big pile of documents, and that was presented to the state, in particular to Ms. Hilda. So, I mean, that is quite distinguishable, Your Worship, from the present circumstances before court. But I must also say to my learned friend for the state that it is entirely unfair. It is below the belt that he should stand up and make a submission that we have been refusing the acceptance of documents, Your Worship. You will no doubt recall, Your Worship, that we have been complaining about the shambolic state in which we keep receiving documents in these proceedings. But we have no less been accepting them, Your Worship. So my colleague for the state should just do the honorable thing, Your Worship, and not brandish us all under the same rubric. Support, please.
Yes, the matter will stand down. The court will indicate when.
Right.